Good evening, this is John Milburn for Laws 13010, Evidence and Proof. We're into week 11, 2017. Tonight, primarily, we're going to deal with opinion evidence. And opinion evidence deals with a number of, if you like, side issues. One of the important ones is identification evidence, and there's also corroboration. So when we deal with opinion evidence, we're talking in many ways about some of the difficulties associated with trying to convey something in a way that is factual but doesn't impinge on the expert evidence rule, and where we are obtaining opinion evidence from an expert, that the expert isn't going beyond what he or she is entitled to say based on her expertise. What we do know is that the court is interested in hearing about what the witness knows of the facts that are relevant to a particular matter, and what are the facts that are relevant to them based on the information they can provide to the court from their own experience. What we don't want is their opinion about the evidence. But sometimes we do, in terms of there are some exceptions to this. One of those is that the court will sometimes very consciously and willingly hear opinion evidence. And we'll talk about what that means. And sometimes that can be expert opinion evidence, or sometimes it can be lay opinion evidence. So when we talk about expert opinion evidence, we're really talking primarily about a situation where an expert comes into court and gives evidence that assists the court in understanding something that has a special body of knowledge that requires some expertise to explain. On the other hand, when we talk about lay opinion evidence, we're not so much interested in what the person draws a conclusion from, but we're interested in hearing their opinion. Now, you might say, but opinion evidence is not admissible. Well, sometimes it's hard to tell. And opinion evidence given by a layperson is often viewed or taken as factual evidence. So evidence of the age of a person, you know, that person looked about 18 or 17 or 18. It's really an opinion. But we let that in because it's the easiest way for us to explain something which reflects what we have seen. So it's a quasi-fact, if you like, but it's really an opinion that's let through. We do know that our system relies on experts. There are some special rules that relate to the expert evidence, but we do know that the courts don't go so far as to allow the experts to replace the judicial process. So the experts are there to provide something, to assist, but not to take over. And it may be that sometimes the courts don't even need an expert to rely on something that is, if you like, common knowledge. And you'll recall that we talked about judicial notice in the past. So if something is of common knowledge, then the courts will make judicial notice of that, and they may not even let an expert come in and make comment about that. And there's a really fine distinction between what's common knowledge and what's knowledge that is gained by the use of an expert. So, for example, you'll recall that decision of Wheel and Bottom, 1966, 40 ALJR at 436. In that case, the expert evidence, and I say that in inverted commas, was given by a truck driver. And the truck driver, from his experience, not necessarily from any degrees or tertiary qualifications, was able to give what was accepted as expert evidence in relation to the effect of a car skidding on a wet road, and dealing with the special dynamics of an articulated truck on a tight bend on the wet road. Okay, so let's talk about a few specifics. One is human behaviour. Now, you might think that for the most part, we are all experts when it comes to human behaviour through the University of Life, and that's fine. And in many ways, what is left for a jury to determine is based on their knowledge and their experience in life And the judge will often explain that to them, that they must make the decision based on their own knowledge, experience, and all that comes into play. So sometimes we don't need an expert to come in and tell us something about human behaviour. Now, it might depend on a degree. So in the case of Murphy against the Queen, High Court decision from 1989, the High Court said that expert evidence of a psychologist would assist a jury in deciding whether certain words and sentence structures used by a 10-year-old were really his own words or her own words. So that was appropriate. That's okay. That's going beyond what we'd normally expect a jury to understand without assistance when it comes to human behaviour. But contrast that to a situation like in Turner's case, where the court said, we're not going to have an expert come in and tell us about the psychological effect on a young man being told by his girlfriend that she'd been unfaithful. Or in R against S, we're not going to allow family services officer to come in as an expert and comment about the behaviour of sexually abused children towards their abusers. So either it's common knowledge or it's something that juries should make their own decision about, or it's an expert trying to give purported expert commentary in relation to a body of evidence that's not recognised as such. So there's a few different ways to attack expert evidence. Okay, let's have a look at the statutory provisions. Under the Evidence Act of Queensland, have a look at, say, Section 9C, and that deals with expert evidence about a witness's ability to give evidence. So it may be, for example, that we have an expert who comes in and says that this particular person can give an intelligible account of what he or she observed or experienced, and that have a look at Section 9B of the Evidence Act in conjunction with 9C in that regard. Okay, so let's have a situation where we have an expert who purports to give evidence. When you're reading the material, when you're thinking about preparing for the exam, think about how you would go about attacking the evidence that's about to be given by an expert. One way is to say that the expert is purporting to give evidence in a field that is not a recognised field of study, and therefore there shouldn't be any expert, let alone this expert, giving evidence about that type of thing. Second is this expert giving expert evidence in relation to their body of knowledge and their expertise, or is the expert going beyond their expertise? Next is the expert evidence purporting to give opinion evidence in relation to something which is common knowledge that people can glean from the school of or the University of Life. So there are different ways that you can try to neutralise expert evidence, and another one is to attack the facts upon which the expert purports to make his or her statement. So if you can show that the expert is relying on factual material to form an expert opinion, then that's the easiest way to attack that expert opinion. It's something that's built on a base that's not well established. And sometimes fairness comes into it. So, for example, in Williams against the Public Trustee of New South Wales from 2007, New South Wales Supreme Court 921, the court ruled that a medical report was inadmissible. The precise documentary material provided to the doctor to prepare the report was not made available to the defendant. Therefore, the court said it's not appropriate for that evidence to go in because the defendant can't appropriately attack it without the material that was given to the expert in the first place. And sometimes you can be very technical about trying to attack the evidence of the expert. Say, for example, in the case of R against Ryan, 2002, Victorian Supreme Court of Appeal 176. It was a rape charge. The conviction was based on DNA samples, and the Crown failed to prove continuity, which means that they weren't able to establish that the sample that was taken ultimately was, beyond reasonable doubt, the sample that was tested, because they didn't get people that may have had some involvement or dealing with that sample on the way through giving evidence. So the continuity was challenged successfully in that case. Now, sometimes experts rely on textbooks, and that's fine. It's technically, of course, hearsay, but the courts will often allow that. But if an expert forms an opinion based in part or in full on a textbook, they need to declare that issue. And just finally on expert evidence, for the moment, you'll recall that there were statements about the ultimate issue, and the ultimate issue was abolished by the Commonwealth in Section 80 of the Evidence Act. And the ultimate issue test at common law was this, that the expert wasn't allowed to give evidence about the ultimate issue or the fact and issue on the basis that that's really the job of the judge or the jury or the magistrate, but that's now been abolished. Okay, let's talk about non-expert evidence. And I mentioned that quite often, in the guise of telling the court a fact, a person is actually giving evidence about their opinion. So to say a person looked angry, or visibility was poor, or the vehicle was travelling fast, really that's an opinion. But we allow that to go in because to do so would make it impossible for people to accurately describe what it is that they're trying to say they saw, or they heard, or they smelt, or they touched. Sometimes you need to support this opinion with some of the facts in detail. So, for example, police officers are well trained, or at least they used to be when they had to do this. If they say that someone was under the influence of liquor, they would then describe the factual basis upon which they came to that conclusion. You know the old saying, we heard it a million times in court, unsteady on their feet, smelt strongly of alcohol, bloodshot eyes, slurred speech, etc. So there's almost a mantra that police, I think, must have been taught because they all said it the same way. Okay, let's have a look at the statutory provisions. Firstly, in Queensland, in the civil sphere, the UCPR, the Uniform Civil Procedure Rules, a few of the important provisions that I want to bring to your attention. Firstly, Rule 423, which provides that in that part, which is Part 5 of the UCPR, the experts have a duty to the court. And the second thing is that in that part, the courts try to have a single expert where possible to avoid unnecessary cost duplications. Have a look at section 426, a handy one to have up your sleeve whenever you're dealing with an expert. And Rule 426 says a witness giving evidence in a proceeding as an expert has a duty to assist the court, and that duty overrides any obligation the witness may have to any party. Also in 427, from a procedural point of view, a very important rule, and it's this. In civil proceedings, an expert may give evidence in chief only by a report, unless the court otherwise gives leave or unless it's in response to another report. So, and that report can only be tendered as required under Rule 429 or if the court gives leave. What it means in practice is this, that if you're calling someone to give evidence as an expert and they've prepared a report and you've disclosed that report under Rule 429, you basically get them into the witness box, identify who they are, their expertise, identify that they've prepared a report, tender that report, and then sit down and let the other side cross-examine. So when you call that person to give evidence, you don't lead them through the report in any formal way. Have a look at 428 and 429, which talk about the issues of the requirements for the report and the disclosure of the report. There are time limits that apply. You've got to be careful with those time limits. All right, so you'll often hear the term conclave, which is really where the courts direct the experts to meet. So have a look at Rule 429 capital B. It's really important, 429B, and keep it up your sleeve. So the courts have the power to direct the experts that may have been called for both sides to prepare a report, and that report says, look, this is what we agree upon, this is what we disagree upon, this is why we disagree, and this is the attempt that we've made to resolve the disagreement. So we're trying to narrow the issues, and that should be presented to the court before we get to the trial. Having said that, where possible, the courts still try to have a single expert rather than both. Now, apologies if my voice is starting to go, partly it's this time of year, but also my internet connection is unstable. Okay, criminal cases, there are special disclosure obligations. Have a look at section 590AH of the Queensland Criminal Code. There's a comprehensive list of matters that must be disclosed. Now, if you're dealing in criminal law in defence, have that section handy, because if you're trying to think of ways to attack the Crown case, one way of doing it is asking lots of questions and asking for disclosure in accordance with section 590AH. It probably drives prosecution crazy, but it's a legitimate thing to ensure that the matters that are subject to disclosure are in fact disclosed. Now, that's the state's fair. Commonwealth, of course, we've got the Commonwealth Evidence Act. The main provisions that I want you to look at, sections 77, 78, 79, but they are the exceptions to the primary section, which is 76. So 76 says, quite simply, evidence of opinion is not admissible to prove the existence of a fact upon which that opinion was expressed. So I think that X drove negligently is clearly an opinion. But there are exceptions to that. So 77 is the exception that allows evidence that is otherwise opinion evidence. And it might be that the opinion evidence is there because it's not trying to prove the existence of a fact about the existence of which the opinion was expressed. Remember that case of Subramaniam? So in that case, the hearsay evidence was admitted not because Subramaniam was trying to prove that the terrorists would actually do something, but was admitted as evidence of the state of mind of the defendant at the time. It's a little bit like this here, in that the opinion evidence is admissible if it's not trying to prove the existence of a fact about which the opinion was expressed. Another exception, 78, is lay opinion. 79 is opinions based on specialist knowledge, which is dealing with experts. And I've already mentioned section 80, which is the other section where the ultimate issue rule has been abolished. Okay, so that's all very well, but how does this actually work in practice? And the main issue to do with opinion is identification, because identification is really an opinion evidence. And it's what you might as well be saying, in my opinion, it was X who I saw that day. Now, you might be able to support that opinion in such a way as to make it admissible, but there are different degrees upon which you might identify someone. You might actually recognise them. You might say, that is my cousin Vinny. Why? Because I know my cousin Vinny. And it wasn't anyone else. It wasn't a resemblance, or it wasn't someone who had characteristics that looked a bit like this. No, I recognised that person. So the first form of identification evidence is recognition. The second is a resemblance. And the third is identification by identifying distinctive characteristics. So keep in mind those things. And Hackett's case from Victoria is authority for the proposition that only recognition evidence should be regarded as direct evidence sufficient to identify the accused and support a conviction. Now, the thing that you might want if you're a defence counsel is a Dhama Can Direction or Dhama Can Direction, but I'll say Dhama Can. It comes from Dhama Can against the Queen, 1992, 173 CLR 555. Interesting case. There we had the witness and husband were victims of an attack by a gunman in their driveway at home. They ducked down behind the car. They didn't get a good look at the gunman, and the witness gave various versions of the identification, and the identification was heavily discredited. But what came about as a result of that case was that wherever identification is a significant factor in the Crown's case, the jury should be given a warning, a Dhama Can Direction, about not only the hazards of identification generally, but also specific points of concern in that case. So if you're defence counsel and you're trying to attack identification evidence, think about whether you should urge the court to give such a direction by way of warning to the jury about relying upon identification evidence in those circumstances. Another sort of identification evidence that's really not used anymore, it's silly to use it, is doc identification. You're not going to see situations where people say, and can you identify the defendant? And they say, yes, it's that person who's in jail, in a jail uniform, handcuffed and sitting in the dock, who's the one who did the crime. That doesn't add anything to the situation at all. And just remember that there is Section 617 of the Police Powers and Responsibilities Act, which deals with photo boards and videotapes and computer-generated images. So have a look at those pieces of legislation. Now, at Commonwealth level, have a look at sections 113 through to 116. And section 116 provides for the direction to the jury. And it's a bit like a Dhama Can Direction. Section 116 in the Commonwealth sphere, Commonwealth Evidence Act, obliges a judge to inform the jury that there is special need for caution before accepting identification evidence and giving the reasons for the caution and the circumstances of the case. So it's really Dhama Can. Okay. Section 632 of the Queensland Code deals with corroboration, and it used to be that evidence that was presented in relation to identification had to be corroborated, but there's no longer any mandatory requirement for corroboration. There are a few exceptions, but generally a person may be convicted on uncorroborated testimony of a single witness. But again, the judge is likely to be guarded and give due warning to a jury in that regard. Now, there are some exceptions to the rule about no corroboration, where the allegation is that the police verbal a confession while in custody. You might ask for what's called a McKinney direction. I've already talked about the Dhama Can Direction, where the court may warn the requirement to have some corroboration in terms of evidence before relying solely on eyewitness identification. So McKinney is a direction that applies where the defendant is in custody and the defendant says that essentially the police forced a confession out of me. Dhama Can, where you've got identification as an issue. And finally, another exception is where a jail guard confession is made and the witness is a prisoner. Sometimes the courts will be very wary about that because the other prisoner may wish to be looking to gain something. Now, another one to think about is what's called a Longman direction. And this sometimes applies, sometimes not, but it's provided to a jury in case where there's a long delay between the date of an alleged sexual assault, and the day of trial. So if there has been a situation where there is uncorroborated evidence in particular, there may be reasons to give special warnings. And one particular case that comes to mind is Robinson against the Queen. It's from 1999, 197 CLR 162, and the High Court gave reasons for a warning where the evidence was that of a young person which was uncorroborated. So in a Robinson warning, the trial judge warns the jury about the special need to scrutinise the evidence of a complainant with great care before arriving at a conclusion of guilt. The requirement for corroboration is also abolished in the Commonwealth jurisdiction. Have a look at section 164 of the Evidence Act. And there's issues to do with unreliable evidence, which are outlined in section 165 of the Act. So have a look at those two sections in terms of corroboration of no longer required and issues to do with unreliable evidence, which is, amongst other things, hearsay evidence or identification evidence, police informants, as we've talked about before, or other certain issues. Okay, now that's all for chapter 11 of the text that I wanted to deal with tonight. Chapter 12 deals with improperly obtained evidence, and even though it's not part of the prescribed reading, I would urge you to read that section or that chapter. Particularly have a look at the way in which certain evidence is excluded if it's been obtained improperly or unfairly. And we have a number of discretions available to a court to exclude such evidence. So there's a general unfairness discretion. In that regard, have a look at section 130 of the Queensland Evidence Act, which provides that the court has power to exclude evidence if it's satisfied it would be unfair to a person who has been charged with an offence to admit that evidence against them. Section 130. And also, this is a really handy one to have up your sleeve. It's kind of a bit odd place, and it's very old, but it's Section 10 in the Criminal Law Amendment Act of 1894. And that legislation provides that where no confession, provides that no confession shall be received into evidence if it was induced by a threat or a promise by some person in authority. So every confession that's made after such threat or promise is deemed to have been induced unless the contrary is shown. And sometimes it doesn't take much for something to constitute a threat or a promise. Mate, I want to get out of here. I really need a smoke. Well, how about I give you a smoke if you come and have a chat to me about this charge that I'm investigating? All right, I will do. So the confession that follows that inducement, I'll give you a break to have a smoke, may be attacked based on that section. Why do we do that? Because there's a fundamental right to silence, and nobody is required to say anything unless it's a voluntary statement. And of course, mere silence is not a sign of guilt. An important case is Swaffield. So keep this one up your sleeve. Arrogance, Swaffield, 1998, 192 CLR 159. And Justice Kirby outlined some valid reasons for silence. Someone who's confronted with accusations might be in shock, so they may not respond, or they might be emotionally upset or confused, or they may not want to immediately disclose an alibi that could be embarrassing. They may not have good communication skills, or they may just have a natural suspicion of police. So Swaffield is a really good one to have up your sleeve if you're trying to argue against perhaps what might be perceived as an unnatural reaction when confronted with a situation that provides for an allegation. Okay, so what are the powers of the court to exclude evidence? There are two basic grounds. Be aware of and be ready to apply the Christie Direction, which is a general it's a general discretion to a court to exclude evidence where what we say the prejudicial effect outweighs its probative value. And there's the Ireland discretion, IRELAND discretion, and that allows a court to reject evidence that has been improperly obtained. Now, the Christie Direction relates to fairness. So what we're saying is that something may have some probative value, it may have some ability to help prove the case, but its prejudicial effect could vastly outweigh any probative value that it has. So a prosecutor might say, if I can get into evidence the fact that this person has already got 3 convictions for robbery in this robbery charge, that might help to prove the case. However, the court would exclude that type of evidence on the basis that the prejudice that evidence would create against the defendant far outweighs any value it may have in proving the case for the prosecution. So the Christie discretion deals with fairness. And again, have a look at Swaffield. Again, the citation 1998, 192 CLR 159. In that case, Swaffield was charged with arson. Police offered no evidence, and then a year later, an undercover officer secretly recorded a conversation with Swaffield. Swaffield admitted his involvement in the arson, so they recharged him. And the Court of Appeal rejected the confessional evidence, and they said it was unfairly obtained and it breached the defendant's general right to silence. Now, there is a direction called McKinney, I mentioned that before, and that's, if you like, a version of the Christie Direction. And it basically says that in McKinney, which was 1991, 171 CLR 468, the High Court considered a confession allegedly made in custody, and McKinney said, look, this is a fabrication. The High Court said the trial judge should have directed a jury to be very careful about accepting such a confession without corroboration, because the circumstances are such that it's a very risky evidence to take into account. Its probative value is not sufficient to outweigh its prejudicial effect. Okay, so that's the Christie Direction and the McKinney Direction, which is, if you like, a branch of it. The other type of discretion is the discretion that relates to public policy, which is the Ireland discretion. And it basically says in the Ireland discretion, which comes from the case of R against Ireland, 1970, 126 CLR 321, the High Court said, look, a trial judge has a general discretion to exclude improperly obtained evidence because not that it would create an unfair trial, but we simply want to discourage unlawful and shoddy practices on the part of police and other enforcement agencies. So it's kind of it's really a public policy thing. We're not going to let the police lead into evidence something which was obtained improperly or illegally, and police and law enforcement agencies have to play by the rules, and the penalty is you don't play by the rules, we're not going to let this evidence go in. So Bunning and Cross, you hear that case often referred to, from 1978, 141 CLR 54, the High Court readopted and reinforced that Ireland discretion. I mentioned before the issue of Section 10 of the Criminal Law Amendment Act of 1894, and you'll recall that there's the exclusion of evidence that was induced by threat or promise, where it's a confession. So in the case of R against Q, 2003 QCA 421, matter that I remember was Q was convicted of entering a backpackers hostel in Harvey Bay and raping a female resident. And 9 days after the event, Q was apprehended in relation to an unrelated burglary, and he thought if he confessed to the rape, he would have a better prospect of obtaining bail, and in that case he was unable to set aside the confession. Also, there was the case of Long. Remember the Childers backpackers murders? That was Long, and when apprehended and shot, Long made a confession saying, "I'm dying, I started the fire," and his counsel unsuccessfully attempted to exclude that confession on the basis that it was induced by violence and therefore inadmissible under Section 10. But the Crown had discharged the voluntariness burden of proof because the violence had stopped by the time the accused confessed. So sometimes timing can be very important in these issues. In terms of Commonwealth legislation, I'm sorry I'm bouncing between Commonwealth and state, but in the Commonwealth, the Uniform Evidence Act, have a look at sections 81 to 90, and they deal with certain issues that relate to exclusion. And that's all that I plan to deal with tonight, other than just say this, that next week I won't have much in terms of set material, but I'm really keen to talk about the exam. I gave some brief notes about the exam on Moodle this week. The exam will be pretty straightforward, and I've put up there the exams from 2015, 2016, and the format that I've written for 2017 is exactly the same. So it's 10 answers that you need to write out of 12 questions. And the fact that we have 12 weeks and 12 questions is not necessarily a coincidence, but it's not directly. Question 1 is from week 1, question 2 is from week 2. But there's a fair spread. Now, if you read the past exam papers, you'll get a good idea of the sort of questions you're likely to have for this exam. So you can write your answers. If you think you can guess what questions are on the paper, then have some pre-prepared answers written, ready to go, or at least have some good notes ready to go. It's open book, so you can take in your own notes as well as a textbook, or take in as many textbooks as you like. Okay, any questions about what we've talked about tonight, or the examination, or the course generally? All good? Excellent. All right. Thank you for your patience. I'm very pleased that we have some people joining us for these live sessions. You've been very good this term. I'm not sure where everybody else is, but I'm sure that we're all listening to these recordings after the event. Okay, well, I'll end the meeting now. All the best, and we'll see you next week. See you then. Bye.